there's a need to know what's out there we have to deal with before we have to call an attorney to get us out of trouble.
Fair.
Awareness is probably one of the best tools we ever have in our business, and this is one of the best guys to preach awareness to us.
Well, thank you.
Fair enough?
Okay.
And I've got to give you a little token of our esteem here.
Excellent. I like the box.
You can sign you can sign the checks for us that way.
Excellent. Okay, good morning, everybody. Those of you who've heard me talk before, I never know where these talks are going to go, so just bear with me. I just kind of go with what strikes me at the particular moment. And I like being videotaped. I'm reminded of Casey Stengel, who hated being videotaped, and whenever he was being videotaped, he always made it a point to say something vulgar, some obscenity, so they couldn't use the audio. Then he would scratch his ass or his crotch so they couldn't use the video. Of course, now they'd use it. So everybody? No. Okay. Okay. Also, when Steve Miller talked earlier about training compliance officers, that's great. But always remember, and if you were here when I was talking with Bart Chadwick, who was a former regional director for OSHA, I got him to admit that OSHA is not concerned with safety. OSHA is concerned with compliance with its regulations. And the purpose of all these words, these thousands of pages and millions of characters, is to get common sense out of the equation. OSHA does not want their compliance officers thinking. They want them to identify violations of the written standards. They're not there to fight, is this safe? Is this reasonable? Is there a better alternative? They're there to take measurements. They're there to see whether you followed the letter of the regulation, and that's what they're there to do. Okay, so you need to keep that in mind, that it's not a question of common sense. It's a question of compliance with the regulations, which is why it's so difficult to comply and do the right thing on a job site. Yeah, Pete.
If I may help you drive that home, have you been out here and been unfortunate enough to have an accident and they come in and do an investigation? I have yet to see one that the citations issued had absolutely anything to do with the accident itself. It's just non-compliance of the regulations.
Correct. It's not to find out how to keep an accident like that from happening again. It's how can we justify our visit. When we do the press release, we can say as a result of this accident, we issued the following citations. They're serious, and here are the penalties, whatever. Okay. You talk politics. I love the fact OSHA was enacted under a Republican administration. Richard Milhouse Nixon was president. And also under that Republican administration, we ended up with the Environmental Protection Agency. So I don't know, when someone says, let's elect a Republican and he'll protect us, think twice about it. Okay, and as you can see, this is a picture that's Ronald Reagan, Gerald Ford, Barack Obama, and Richard Nixon. Okay, this is not in the PowerPoint or the keynote presentation on your little disk drive, because I figured you can read that later. I thought what I'd start to talk about today is to talk about the 3 most recent OSHA cases I've had in the office and how they've resolved. Now, the reason I'm talking about these 3 cases, like anybody who's typical lawyer, these are cases that had a good outcome, all right? And I take responsibility for it, so that allows me to talk about it and pat myself on the back. But the first one deals with a fatality. The second one deals with a Jersey wall falling on a trench being dug for footers. And the third one involves Portland cement and cleanup. All right. The fatality involved, this was a properly plumbed, properly braced wall that fell over, killed one employee, severely injured another, Okay? Walls do not normally come over, correct? That's something that should not happen, right? This particular client, who has been to all kinds of seminars and talked to me and have been trained, the first thing they did was they got everybody off the job site back to the office to find out what happened in a calm, more friendly environment. All right? You don't want the government talking to your employees on the job site where there's a body there under concrete or whatever. It's very, very emotional. We got them off the job site, and I met with them that morning within an hour of the fatality. And we launched into an immediate investigation to find out what happened. And why do you need to do that? You need to do that so that you can present the facts to OSHA, not have your employees present theories, and then OSHA goes back with its compliance book and reads through, and it's like Pete Walker says, they decide, okay, we can't cite him for this, but we can cite him for that. All right, so what we did was we interviewed all the employees, all right, and we did something that I think was a very, very good exercise. We tried to figure out all the possible ways we could have screwed up, all right? Our foremen, our employees, we cataloged it. We wrote it down. We said, okay, assuming worst case scenario, why do walls come over and how does it happen? And we went through it and we eliminated every single theory. We got statements and corroborating evidence for every single theory. We disproved all of the possible causes. Okay? And we did that by being calm, rational, playing devil's advocate, whatever. The result was no citations. Okay? This was such a big deal because this was a visible job in the state where it occurred that the newspapers had a field day. And when the client called up to say, they're saying horrible things about us, and I said, no, they're saying horrible things about OSHA for not citing you. Better that they should be saying horrible things about OSHA than horrible things about you. All right? And as a result of this, as a result of immediately figuring out what happened, immediately taking statements so that by the time OSHA got involved, we at least knew what had happened, or we at least knew what didn't happen. No liability lawsuits can take place now, no expensive litigation. All right. That, yes?
I have a question. Does anyone, such as OSHA representative or contractor, anybody, have a right to keep your employees from leaving the job at that point?
OSHA, no. The police, yes. The police power, they can prevent them, but, from leaving. But you can say to the police officer, you can talk to my employees, but this guy, not without a warrant. All right? As a matter of fact, my son, who's in the industry, made a general contractor, one of the general contractors whose name was mentioned a few minutes ago, nearly pass out when OSHA, I think in this case it was VOSH, came on the job site and they wanted to have interviews of his employees. And he said, not without a warrant. He said, you could have sworn that the safety officer for the GC was going to pass out. And you know what? No citations. All right. Okay. Second situation, the Jersey wall that came over. Okay, wall falls in, an employee's foot is crushed. There are photographs in the OSHA file showing that the guy lost 4 toes. All right, pictures of his foot. Okay, I didn't even know about this accident until the citations were issued. So consequently, the client allowed OSHA to interview all the employees, to interview the foreman, and then the client said, you know what? I think we probably should create an employee misconduct defense. So we know, so we're going to discipline people for this. So who do they discipline? They discipline the operator. Okay, that seems reasonable. And they discipline the foreman. Okay? Now, again, if you're going to discipline the foreman, doesn't that suggest that one of your representatives screwed up? Okay? But that's what they did. So they issued a serious citation with a huge penalty. All right? So we contested. We went to an informal conference. They, OSHA dug in. Okay? And also I said, I didn't have all the facts. I kept saying to the client, I should really talk to the foreman. I should really talk to the operator. And he said, nah, you got everything you need. You got everything you need. And that's fine. I said, okay, what that means is he's going to allow me to go to trial. I mean, it's music to my ears. If a client has retained me in an OSHA matter and he doesn't want me to do an investigation that will allow me to get rid of the case in the early stage, it means we're going to trial, baby. Okay, so that's good news for me. So we found ourselves a week before trial. I said, okay, now I want to interview the foreman and the operator. I said, oh, the operator quit a month after the accident. And this is nearly a year later. And it turns out that the operator gave a statement to OSHA saying, nobody told me to stop digging in the area near the Jersey Wall. No one told me to stop digging, which was true. The foreman told him to dig in another area. But now they've got a statement because we weren't there, we weren't involved, we didn't make sure that OSHA had all the facts. They have a statement that the foreman didn't stop digging. So doesn't that even suggest to you that we're at fault? We knew that this was going to happen because we let the guy dig? Well, I talked to the foreman, and the foreman had actually told him to dig in another area, had gone over to supervise another area, and couldn't even see where the guy was digging. All right, so we didn't have knowledge. So I said, okay, that's good, but how do we explain the discipline? Okay, because one of the things, I'm one of those lawyers who doesn't like to risk my license by lying, having my clients lie under oath, destroying evidence. I mean, I'd like to, but I really do enjoy eating and making money more than I enjoy, winning a case, certainly under those circumstances. So I had to come up with a reason for disciplining the foreman. And what I did was I remembered Animal House. My favorite line in Animal House, when Flounder lets the guys use his brother's car and it gets wrecked and they come back and Otter puts his arm around Flounder and he says, Flounder, you effed up. You trusted us. Okay? So I said, okay, we discipline this guy for trusting the operator in a dangerous situation to do the right thing. And guess what? I convinced OSHA to reduce it to an other than serious. And other than serious for a crushed foot with a Jersey Wall. But at least by that time we had constructed the defense, which we could have done. We might have done, if we had done it early enough, we might not have seen any citations. The best I could do was an other than serious at trial. All right. Third, the Portland cement. Portland cement, I didn't even know there was such a thing as a Portland cement. Is there a Seattle cement or whatever? But apparently it's a caustic cement. If it gets on your skin, it can cause some problems. And this client didn't have any running water. It was a concrete contractor. Didn't have any water, but he had some sort of solution, Natural Light or something like that, to rinse it off. And they issued a serious citation for not having a washing station for employees to wash their hands. And I said, well, what's our defense? And they said, well, we have this solution that we use on the site. And I said, did you tell OSHA that? And he said, no, we didn't. They asked us if we had water on the site, and we said no. All right? Again, they're answering the wrong questions. They're not thinking. They're not being, responsive, and they're not preparing. So they issued a serious citation. At the informal conference, as you know, OSHA is, for those of you who've dealt with OSHA, you know what they like to do. Once they issue citations, what they want to do is they want to do you a favor by cutting the penalty, or if they're going to be really, really generous, they're going to reduce it from a serious to an other than serious. The problem is that that doesn't prevent them from citing it later as a willful or as a repeat, and the fines go way, way up. But they offered it. Okay, other than serious, because you had this solution on the site. And the client said, take it. And I said, no. I said, we're not going to take it. It's not going to cost any money. We're going to let him stew. We're going to tell him we're going to trial. And that you talk about this with the Assistant Attorney General handling the case. They did, and on the drive here Wednesday, okay, I got a phone call from the compliance officer that they were going to rescind the citation. Okay, so what can you learn from these three cases? All right, one is to stand firm, push back. The government, these government employees who, look, you can go out for a beer with them. They're wonderful people. They're fine, fine human beings, but they are human beings nevertheless. They don't want extra work. They certainly don't want extra work that ends up with nothing to show for it, and they certainly don't want to deal with people who aren't as cooperative as can be. Remember, for those of you who heard me talk before, who was the OSHA compliance officer going to want to inspect? The guy who busted his chops the last time he tried to inspect a job, or the person who let him in, gave him coffee and donuts? Okay, human nature says, I'm going with the coffee and donuts, right? But if, you know what, if I got a choice between coffee and donuts and the pain in the neck, I'm going to inspect the coffee and donuts guy every time. The other thing is, don't let OSHA control the inspection. You control the inspection. Remember, they can always go for a warrant. I've been doing this over 30 years, and I have insisted on a warrant countless times. Do you know how many warrants have been issued against my client in 30 years? Take a guess. 0. You know why? Oh man, that's a lot of paperwork. All right? And we have this little dance in Maryland. John Krasnoff is the Assistant Attorney General who goes in for warrants. And what happens is, one of my clients refuses to let him in without a warrant. John calls me and he says, can we work out a deal? And I'll say, well, John, what do they really want to inspect? Well, there was a complaint about a guard on a machine. I said, they want to inspect the machine? I'll talk to the client. And then we arrange for him to go, inspect the machine. We make sure there's nothing else going on in the vicinity. They inspect the machine, and they're gone. Otherwise, what would have happened? Wall-to-wall inspection. All right? Okay. And whenever you have a fatality, you can insist that the inspection be restricted to the fatality. And then we'll always say, it's protocol. Whenever we have a fatality, we do a wall-to-wall inspection. And you can say, well, that's not my protocol. If you want to do a wall-to-wall inspection, you've got to get a warrant. But if you want to inspect the accident, we'll let you do that. And by the way, here's some statements we took from our employees explaining exactly what happened that shows we didn't do anything wrong. All right? Okay. Let's talk about OSHA Live, the top 10 citations for 2011. And then I'll do the top 20 for steel erection, some of which is overlap. Scaffolding. Now, why do you want to know, Casey Kasem's greatest hits? Why do you want to know the countdown? Okay. Remember, these very wonderful beer-drinking OSHA inspectors, all right, again, are human. People tend to do what they're familiar with. And as you know, almost every OSHA compliance officer creates a niche. They're guys who like cranes. They're guys who like the fall protection. They're guys who like lockout, tagout. They're, you know, and what happens is they develop a little bit of expertise. This is what happens with lawyers, right? I do one case in an area that's new. I'm now an expert in that area of the law. Well, that's what happens with OSHA inspectors too. So you should know what flavor of ice cream they like. And you got to make sure that you concentrate on those areas. All right? The number one citations for, the most citation for 2011 by OSHA was scaffolding. All right? And we all know scaffolding, again, is a fall protection kind of thing. Which is number two, fall protection. The number two, anybody recognize that picture? The high diving horse in Atlantic City on the Steel Pier in New Jersey. I grew up 5 miles from the Steel Pier. My cousin Joan Hackney is the woman on that horse. And it was the cruelest thing. If you've ever seen that horse jump in, it never looked like the horse wanted to do it. All right? And you can imagine Peter's going to let them do it, right? To redo it. Okay. Number 3, hazard communication. All right. That is the greatest picture. That, to me, is the picture that's going to be in all my PowerPoint presentations from now on, especially with hazard communication. Now, you know what hazard communication is? Low-hanging fruit. Okay, because everybody here's got a material safety data sheet missing. Everybody here's got a guy who's missed the training and whatever. Okay, so it's probably not a bad idea for you to make sure that the hazard communication is part of your training protocol, and maybe the toolbox meetings, in addition to fall protection, ought to talk a little bit about. And you know where the material safety data sheets are and all of that. And for those of you who are in Maryland, you know you've got to send a chemical information list to the department. I think it's now the Department of the Environment every 2 years of all the chemicals that you have in the workplace subject to hazard communication. And again, low-hanging fruit, it's very easy for them to say, well, did Phoenix do the list this year? No. Okay, so you'll get a citation for that. Okay. Number 4, respiratory protection. Number 5, lockout, tagout. All right? Again, that's easy. Lockout, tagout is always great whenever there's an accident. Okay? It's easy for them, again, low-hanging fruit. Well, the machine should have been locked out or, you know, tagged out or whatever. Okay? We had a case years ago sort of in the industry where an employee took the grate off the interior of the wheelabrator. There was an auger in there moving the shot that was used to clean the girder, and he got ground up. All right? And of course, we're trying to figure out, nobody knows how he got in there. And I said, well, lockout, tagout. You got to have that. That was the citation. Now, we won the case, but still, that's very, very popular whenever there's an injury involving a machine. By the way, that's the only OSHA case that I've ever been involved in where I'm absolutely convinced that the cause of death was murder. All right? And it was just something in my gut, but the person who discovered the body and the person who was looking for him frantically an hour before he discovered the body was the guy's best friend, who is now married to his widow. All right? But it's very difficult to explain to OSHA that our defense is murder. All right? So try to come up with something better than that. Okay. Number 6, electrical wiring methods. All right? Again, all you need to do is see some wires out there, and OSHA goes and they gets their compliance book out. They get their compliance book out and they say, okay, this should be this should be that, this should be this. All right? Number 7, powered industrial trucks, forklifts. All right? And forklifts do get into accidents all the time, right? My first out-of-state case was in Rockford, Illinois, for a company that made cathode ray tubes. For you youngsters, that's what used to be television sets, okay? And they made these things, they were glass blowers, basically. And something like 80% of their workforce was female. And the only requirement of the job was that you wear steel-toed shoes and eye protection. And in the summer, in Rockford, Illinois, it gets hot, very, very hot. And a lot of the women will show up in the skimpiest of outfits. And they booked 2 forklift accidents every summer, at a minimum. Because it was usually a male forklift operator who would be going around, and he would look, and before you know it, he would crash into something. All right? Forklifts also, you know, as you can see here, that kind of stuff happens all the time. And I understand, you know, even in your, you know, in the steel erection industry, you use things that qualify as forklifts and, you know, material movers and things like that. And those things get into accidents. People bump into stuff, people get hurt. I actually had a steel erector have an employee killed where a large powered industrial truck ran over an employee. And that was one of those cases where we, again, figured out how it happened. Nobody knew how this guy ended up under the tire. So we spent an hour or two right after it happened talking it out, saying, okay, what are the theories, where was everybody? And we figured it out, which is something you can do if you take the time and you're rational. And we figured it out. OSHA did not issue any citations. All right? Number 8, ladders. This is something near and dear to you, right? Ladder citations, again, low-hanging fruit. How many times have I heard in the last 30 years, that wasn't our ladder? All right. Or they borrowed our ladder, especially in a liability case, right? They borrow one of your ladders. You know, maybe you ought to paint on the side of your ladder, use by anyone other than the employees of blank is prohibited. All right? But ladders is a big deal. And again, all you have to do is have the OSHA inspector looking around, and he goes and he's got his tape measure, and he wants to measure how far the ladder extends. You know, so he goes and he measures, and if it's not the right amount, you get a citation. Number 9, electrical general requirements. I don't know how that's different from the earlier one, but it's just a different standard. Obviously, electricity, people get killed, people get electrocuted, cited all the time. And number 10, machine guarding. And this is where, you know, you do have a lot more control over your shops than you do over your job sites, correct? Okay. So when you're talking about your shops, where you control the property, where you own the building, where your machines are, where you're doing your fabricating or you're doing, you know, any of the preparation work, that is your house. And OSHA or cops trying to get into your house to find evidence of a crime. You can and should keep them out of your house until you find out why they're there and that you're not liable for any sort of you know, citations if you do let them in. I have one general contractor client who, I have several general contractor clients, but I have one who insists on a warrant every time on a job site. And people love working for that guy, all right? Because he says, look, I'm going to get cited just like these guys, right? If I let them in, they're going to suck me in and say I had supervisory authority over the subcontractors, and I'm going to get cited as well. He said, well, if I'm going to get cited, I might as well, you know, be on their side, as opposed to other general contractors I know who throw you under the bus, stomp you, on the way under the bus, and then when the bus is over, they deliver your body to OSHA. All right? But even on a construction site where you do have some control is interview of your employees. Okay? OSHA does not have the right to interview your employees. And what can you tell your employees? You guys have heard me say this before, at least the people who have heard me before. You can tell your employees that it is their right to talk to OSHA if they wish, but it is also their right not to talk to OSHA if they don't want to, and we would prefer that you not talk to them. That's perfectly legal, perfectly proper. Foreman, you can insist. You can say to a foreman, not only do you not have the right to talk to OSHA, if you talk to OSHA other than say, my boss will be here or the safety director will be here in 10 minutes and he'll answer all your questions or something like that, or learn him to say, I'll find out, I'll get the answer for you, unless you can tell a foreman that that's what he ought to say to OSHA. Machine guarding, that's always a tough one because every time I've seen a guard on any kind of machine, whether it's a press brake or a shear or something like that, the best employees know how to disable the guards to make their job easier. Okay? So what you need to do is at least make sure that the guard is there, okay, so that if OSHA does happen, if one of the receptionist who hasn't been properly trained somehow lets OSHA in when everybody's, when all the managers are out and comes in, you don't want the guard to be against the wall covered in about 2 inches of soot and dust. All right? You want to at least be able to put it up. Yes? Well, you don't control the job site. So if the general contractor says to OSHA that they can let guys go up on the steel or take pictures or do whatever, you can't stop that. But if the general contractor says, I want you to have your employees come to the trailer and be interviewed, the answer is no. Not on my time and not without a warrant. And if they do show up with the warrant and the warrant says employee interviews, it has to say private employee interviews, or you might have the right to be there. Okay? And an employee can say to OSHA, I'll talk to him, but I want the boss there. All right. Think that picture's real? I guess it is. All right. Top 20 for steel erection. Fall protection. That's a big surprise, right? Aerial lifts. All right. My firm represents JLG and all of their various, I guess they are now by Oshkosh or whatever. But I made the mistake of calling it a cherry picker the first time I met with the general counsel. And he told me it was an aerial lift, and if I ever said cherry picker again, he was going to find another lawyer. So I listened. Okay, but aerial lift citations. Scaffolding. Subpart M, fall protection. How about that? You see the first one, fall protection, that's subpart R. Okay? Subpart M also applies to steel erectors when they're not engaged in steel erection. And as you know, the definition of steel erection in subpart R is specific. And you can be cited, the fall distances change, the requirements change, and as those of you, because again, OSHA writes complicated regulations, a lot of subpart R adopts subpart M requirements. Okay? Not to the distance, but as to the type of equipment used and things like that. Number 5, ladders. Okay? Number 6, arc welding and cutting. Number 7, gas welding and cutting. All right? Not a surprise. Okay? There's always the welding leads and stuff like that. It's always very easy to find a welding lead that needs to be taken out of service or needs to be repaired. Okay, so you really need to be aware. And again, that's something you can teach a nincompoop to look for. Okay, something you can teach a compliance officer to look for. You say, go into the job site, look at this, and if you see a cut, take a picture of it, and we'll figure out whether we do a citation. And you know, that's been the, when I first started doing this years ago, OSHA would almost always tell you what you were going to be cited for. Do you guys remember the old timers? It was always at the closing conference, they would tell you what the citations were going to be. Now they don't do it. What they do is they go back, because the books are thicker and bigger and more complicated, and they review all of that, and they review all of that, and even at the closing conference they say, it appears that we may cite you under, and then they have 6 months from the date of the inspection to issue the most complicated citations possible. Stuff that the OSHA compliance officer didn't know was a violation when he was there. All right? But if you take the right picture, or if you take the right notes, or if you get the right employee to say something stupid, you can go back to your OSHA office and you can find a reason to cite. Okay. Fall protection systems and practices. So you see there's 3 fall protections in the top 10. The first one, subpart R. The second one is subpart M, fall distance. The third one is the fall protection systems and practices, which are controlled by subpart M. Then, of course, my favorite, training. All right, it's a catch-22, right? Whenever OSHA says, okay, there's a violation, the employees weren't properly trained, so therefore we have a training. All right, if there's no violation, they now still say, well, what training have the employees had? Again, there's always one guy who slips through. And if OSHA really wants to issue a citation, they'll say, okay, let's see the training records for the people on this particular site. And then you've got a guy who's been an iron worker for 25 years, so guess what? You didn't process him when you hired him 6 months ago to show that he had the training. And so he's been 25 years. He's obviously been trained. That won't wash it. All right? Head protection. That's again the hard hat. Okay. Material handling equipment is number 11. Number 12 is the general duty clause. Okay, now you know what, those of you who don't recall, the general duty clause is basically when OSHA was created in 1970, they said, okay, we're going to issue regulations, but obviously we can't cover every possible condition. So we're going to make it a violation for an employer to create a recognized hazard likely to cause serious injury or death. And you can be cited under that for serious, and you can be hit with a huge fine. Typically it happens in cases where there are accidents where they can't figure out what went wrong and what to cite. And what is a recognized hazard? A recognized hazard, for example, let's say Pete Walker decides that he's going to be super duper vigilant and he's going to have crane standards that are beyond what OSHA requires, okay, because you don't want to have trouble with these general contractors, and he does that. Has Pete now recognized a hazard beyond what OSHA has? I think OSHA would make that argument, so that it's, again, a catch-22. If your safety program exceeds that required by the OSHA standards, you may be creating a recognized hazard that OSHA can look at your safety manual that you throw at them to show what a great job you've done, and they say, well, wait a minute, you're not doing this, you're not doing that. And I say, well, that's not required by the regulations. Yeah, but that's a recognized hazard, otherwise you wouldn't put it in the safety manual. So be very careful. Obviously, it's the number 12 highest citation for steel erectors. Rigging equipment for material handling, wiring method, training for fall protection. Here's hazard communication, still in the top 20. Wiring design, forklifts, powered industrial trucks, general safety and health requirements. You all remember it's a section 20 that's sort of like the general duty clause that says you'll provide a safe and healthful working environment. If they can't get you on anything else, they'll get you on that. And then training in lifts and scaffolds. All right? Those are the top 20. Now, Charlie's okay for me to go to something like 10? Because it's a quarter of now. I'm due to quit now. I started about 15 minutes late, and I take my time seriously. I don't think that anybody wants to listen to me longer than they have to. All right? Okay, get a few minutes? Okay, very good. Let me tell you about OSHA in the last few minutes of why they're still alive. I'll tell you sort of what's happened. I was talking to Craig Lowry, and people here from Maryland, you know Craig? Do you know Craig's the assistant commissioner now? Who'd have thought it, right? Peter Principal. Okay? Well, Craig Lowry told me the other day that OSHA, the AFL-CIO hates state-planned states. And you know why? Because they can't control them like they control the Department of Labor. All right? The most successful thing Barack Obama has done as president, if you call doing something he said he was going to do a success, is that he has rewarded the union people who helped get him elected. And they did help get him elected. The Service Employees International Union, I forget what the president's name was, but within months of being in the White House, he said publicly that they're consulted on stuff by the Obama administration, including stuff that's unrelated to labor. All right? And they were the people who manned the phones, that got people out to vote, and stuff like that. So what has Obama done? He stacked the Department of Labor with AFL-CIO people who are, again, I have friends who are union people. I deal with lawyers who represent unions, and they're fine people. But they don't think like management. All right? It's just like, the difference between men and women, management employees. You do think differently. It doesn't mean that you're wrong, you just think differently. And their mindset is employers are bad guys. All right? People that you got to keep an eye on. And Hilda Solis, who's the Secretary of Labor, she said a couple years ago when she was appointed, there's a new sheriff in town, and I'm going to clean up this mess, meaning these horrible employers who are getting away with murder. Well, little did anybody bother to look to see that nobody was getting away with murder under the Bush administration when it came to OSHA, and certainly nobody was getting away with murder with the Department of Labor. All right? However, now there's newfound emphasis. And this particular page, which I don't know that you can necessarily read here, but maybe you will on the PowerPoint that came with your packet, is that OSHA is encouraging employees to go to their website, to search their employer, find out the violations that their employers are doing, and whistleblow on their employers. This stuff is outrageous in how they're encouraging employees not only to report their employer without any risk of being disciplined because it's against the law to discipline or fire somebody for reporting a safety complaint, okay? But they also want them to refuse to do work that they believe is dangerous. Now that's a slippery slope. From my perspective, everything you guys do is dangerous. All right? So it seems to me if you hire an iron worker to do something, and it's typical iron work, unless it's an unusual danger, he shouldn't be allowed to refuse to do the work. But that's what they're encouraging. And Sort of to close on this note is something that happened, another war story, if you don't mind that, is that one of my clients recently had a job where they were hiring, they had a difficult time finding people because of the welding on the job who were competent. So they went through nincompoop after nincompoop after nincompoop until, and they found 3 guys who were African American who were not complete nincompoops, all right? They were fair, all right? Not good, but fair. And what happened was they finally had some qualified welders who had worked for the company free up, a chance to get rid of these guys. But because we're all very conscious about being sued, you figure, okay, you got 3 African American employees who are marginally okay. Maybe we'll try them on another site, all right? So they transfer them to another site, but this site's not Davis-Bacon work, all right? So they quit the first day and they say, we were fired or transferred and made to quit because we complained about safety. And we have now had to go through half a dozen interviews with the Department of Labor, not over race discrimination, but whether they complained about safety. Now, the foreman on the job never heard them complain about it. The general contractor said they never heard any complaints, although they said they went to the general contractor. The project manager heard no complaints, all right? So we're doing great. The safety officer who works for the company, as I'm getting her statement, she says, oh yeah, one of them complained at a safety meeting and it's in my minutes. And I said, I'll call her Joe for Joanne. I said, Joanne, why didn't you report this, or why didn't you note in your minutes that it was resolved to the employee's satisfaction? Because it was. All right? So now we had to deal with, again, what appeared to be a smoking gun. Train your people as much as you can that if they're going to write stuff down, tell them to imagine that somebody else may read it someday. Okay? And that somebody else may be a government official, a lawyer, or something like that. If somebody complains about safety, you write, and you're going to write it down, you talk about the resolution, and you close it, meaning the issue, in that document right then and there, so that you can say, when somebody says, I was fired because of safety, what is the correct response? Bullshit. Okay? All right. Any questions? I've got to go to I've got a conference call that I have with a judge, but I'm going to come back at lunchtime and hang around this afternoon. So feel free, anybody have any specific questions, come see me, okay?